Toitu te marae a tānei, toitu te marae a tangaroia, toitu te iwi. Ko maunga nui toku maunga, ko kaihu toku awa, ko hokianga toku moana, ko ngāta whātua ko ngāpui oku iwi. Ko tamata ua ua toku marae, ko wirori toku whānau, kei tauranga toku kāinga noho, ko LaraBurkehardt toku ingoa. Kia ora koutou katoa. Tuatahi, he mihi ki te atua I runga rawa tēnā koe. Tuarua, ki te whare I tu nei, kia papatuanuku e tā poto rā tēnā pōrua. E nā mate, haere, haere, haere atu rā, kia tātou te hunga ora, tēnā koutou, tēnā tātou katoa. I first want to acknowledge the whakatauki I started with. I recently read this in the submission of Te Runanga o Tūrana Nui a Kiwa that was recently lodged with the Gisborne District Council, who are in the process of reviewing their freshwater management plan. And I thought it was appropriate given the topic of this conference. If you've read the Resource Management Law Journal article that was included in your materials, did anyone read the article? Good. It's going to be apparent that I'm neither of the authors, who were Vanessa Ham and Bridget Bailey. But because of school holidays, she's not here, and it is my absolute pleasure to stand in her place to talk about the article. Most members of the New Zealand, actually before I start, I've been here for most of the presentations, and there's been some awesome slideshows that took you off into faraway places. My slideshow is not like that. My slideshow is mainly excerpts from the Resource Management Act, the NPS Freshwater, and the cases I talk about. So don't try and read them, they'll give you a headache. And I go through them quite quickly, but they will be available for you after the presentation. So for most members of the New Zealand public, I would suggest that this issue only became, or the issue of Māori rights and interests in water, only came to their awareness as part of the Mighty River Power and Marine Energy asset sales in 2013 and the court action and Waitangi Tribunal claims that responded in an attempt to protect Māori rights in water. As reported by the Waitangi Tribunal on stage 1 of the freshwater inquiry, the issue of Māori rights in water is not new, it's not novel, it's not opportunistic. And you heard from Willie and Linda yesterday on that topic. However, arguably, central government attention, and to an extent local government attention, on the extent to which these rights and interests can and should be provided for is relatively new, and this is partly due to the Waitangi Tribunal rulings, but also, I would suggest, due to the general shift in thinking toward better recognising tangata whenua rights. Now, this is a vast topic. There are options for providing for these interests that involve fundamental shifts in the principles that underlie our present resource management system, particularly where the discussion extends to talk of ownership in water in the typical common law sense of the word. However, that's not what I'm going to talk about today. What I'm going to focus on is what the current resource management framework allows in terms of the allocation of water for iwi, either for their use, and what could be changed to provide for this without a fundamental shift in mindset. An iwi allocation would involve a new categorisation for water use, and the article considers how this would work under the current regime rather than under a new system altogether. Don't get me wrong, I think that any change in this regard, even somewhat subtle, would still involve a change in the way many people think about the allocation of water, but the system does not need a wholesale review in order to achieve some of the outcomes that iwi are seeking. My talk today, and the article that it is based on, looks at whether an allocation of water to iwi, or something similar, can be achieved under the RMA as it currently stands, and what changes could be made to allow for this to occur without overhauling the system in a more fundamental way. So in particular, I'll cover whether it's legally possible to have an allocation of water for iwi under the current legal framework. Second, look at how far the boundaries have been pushed, and if there's no ability to have an iwi allocation, what can iwi look to achieve in terms of allocation under the existing framework. Third, what needs to happen to take it a step further and allow for an allocation to iwi. And finally, what are some of the implementation issues with making that kind of change? When I refer to an allocation of water to iwi, I'm talking about a rule in a regional plan that says X amount of water or X percentage of flow is to be reserved or set aside for use by one or some iwi groups. The rule would allow iwi to abstract a certain volume of water and use it for their economic benefit or commercial use. Whether the use will be by iwi themselves to support their own developments, or to support developments undertaken by iwi in partnership with someone else, or through the leasing or transfer of those water rights to others for their use. I'm not talking about the amount of water that should be retained in water bodies to protect cultural values. That is certainly something that the current system does provide for. I also do not suggest that the allocation would confer a right that is somehow different to what is provided for under the current regime. That is a right to take and use water for a defined period of time that's presently 35 years, or no more than 35 years. A perpetual right to take and use water is not provided for under the current regime, and in my view, this kind of outcome would present a much greater shift in the underlying principles which govern water allocation. However, despite the limited life of a consent, the reality is that water permits have many of the characteristics of a property right, as it creates valuable rights to water and gives the consent holder control and exclusive use of that water for the term of their consent. In effect, water permits do confer valuable rights that are proprietary in nature, and this characteristic is relevant in particular to the implications of any changes to the current framework, such as considering how the rights of existing users might be affected. So is an iwi allocation for economic development or commercial use legally possible under the RMA? The view of the authors of the article, and I agree, is that an allocation of water to a certain group of people does not appear to be possible under the current Act. However, it does seem that there is scope to allocate for cultural uses and potentially even to link an allocation to the type of land such as Māori land. To explain to you why that is, I'm going to take you briefly through the relevant sections of the Resource Management Act that say how water is to be managed, as well as some of the cases that have considered the issue of allocations to iwi. This is where you're going to get a headache if you try and read. So the starting point is section 14, which sets out the restrictions relating to water. Section 14 contains a presumption that you can't do anything with water unless you're expressly allowed to. And this presumption applies to all water-related activities, including discharges. This is different from activities using land, like subdivision or building, where you can do those things unless something says you can't. So under section 14, you cannot take water unless that take is allowed by a national environmental standard, a rule in a regional plan, a resource consent, or in limited situations prescribed in this section for domestic needs, animal drinking water, or for firefighting purposes. Section 30 includes the Regional Council's functions with respect to water allocation. Councils can set maximum or minimum levels of flow, such as setting the minimum level of water that needs to remain in a water body and cannot be taken out to protect upstream values, and those are known as flows or ecological flows. The Council can also establish rules which allocate the taking or use, and importantly, may do so in any way, subject to express limitations. The main limitations relate to existing uses of water. The Council cannot have a rule that allocates water that is already allocated to somebody else. It can allocate water in anticipation of those existing consents expiring. That is, when the consent expires, water could be earmarked via a rule for a different use. The only way a rule can affect an existing consent during its term is to meet new environmental standards like new water quality standards or new higher minimum flows. A rule may allocate amongst competing types of activities and cannot affect the activities authorised in 14.3. Those were the needs of domestic needs, animal drinking water and firefighting. So you'll notice that there is a clear focus on activities and allocating to types of activities. When I come to discuss the court decisions to date, you'll see that the explicit use of these words has played an important role in decision making under those cases. In circumstances where a council wants to establish some form of differentiation or preference in its water allocation regime, the Act suggests that this is to be based on the type of activity that water is to be used for. And the relatively common types of activities that I'm used to seeing in water allocation frameworks are things like municipal water supply, renewable electricity generation, irrigation, coast protection. What the article concludes, and I agree, is that an allocation based on the iwi status of the consent holder does not squarely fit as an activity under Section 30 of the Act. This approach is also the current state of the case law, which has established that while a council can give preference to a class of activity or by reference to the effects of activities, it cannot give preference to a particular section of the community. The issue of an allocation of water for customary or cultural use, as distinct from commercial use, may well be able to be considered as a separate category, and I discuss this later in the presentation. Sitting directly below the RMA, but above local planning documents, is the MPS, or National Policy Statement for Freshwater. First came out in 2011, it's been amended in 2014, and we heard yesterday as part of Willie and Linda's talk that we're going to get another one soon, or an updated one. So, for the purposes of this topic, Objective D1 requires councils to ensure that tangata whenua values and interests are reflected in the management of and the decision making on freshwater. And within the MPS, under the National Objectives Framework, there are already some cultural values identified. For example, He Ara Haere, Tai Tapu, Mahi Kai. However, interests has been left undefined. The process of defining these is presumably to be left to local processes, although one would expect some guidance should come out of the central government-led process that is currently underway. Objective D1 also requires the involvement of tangata whenua in freshwater management, and Policy D1 requires councils to take reasonable steps to achieve this objective. While the freshwater MPS may be considered by some to give further support for the notion of an iwi allocation, it does not change the underlying Resource Management Act framework, and the constraints within that framework that I discussed remain. So how far have the boundaries been pushed to date, and what is possible? The article discusses three main cases where these issues have been raised, and I will talk about them today as well. I was involved in two of them, the Karaho Harvey or Variation 6 case, and also the Matamakino cases, and I represented the interests of existing renewable electricity generators in those cases. In all of them, the courts upheld the notion that the RMA can allocate a resource by activity or category of effect, but that it does not contemplate an allocation by user. However, the cases also show how far the boundaries have been pushed to date and help identify what is possible under the current Act. I'm also going to discuss the Tasman Regional Plan, which was not tested in the courts, but it includes an approach that links taken use of water to Māori land. So the Hauraki Māori Trust Board, 2004. This case involved the council seeking to vary its regional coastal plan to establish a marine farm zone south of Coromandel. The Trust Board were acknowledged to be tangata whenua in the area, and at that stage had made a claim to the foreshore and seabed. A Waitangi Tribunal report on aquaculture claims had also found that Māori have an interest in aquaculture and marine farming. The Trust Board sought an allocation of a percentage of the coastal space within the new marine farming zone. It did not specify the amount it considered appropriate. Their case relied heavily on the Māori provisions in Part 2 of the Act, that's Section 6E, 7 and 8, but the Environment Court held that in the absence of authorising legislation, the preparation of regional plans was not an appropriate vehicle for either resolving or addressing treaty claims or other iwi grievances. Any claims to ownership or redress for grievances based on the treaty, the court said, were for the Crown in its executive capacity and not for the Environment Court. The case was struck out and the Trust Board appealed to the High Court. The High Court was not persuaded that the RMA authorises the regional coastal plan to differentiate between individuals or groups in the way suggested. They said there's nothing in the relevant provisions of the Act which expressly or impliedly authorise a regional council to provide those kinds of provisions, giving preference or priority to tangata whenua. They also said that the Act focuses on the authorisation of activities. It does not contemplate the making of rules which would give such preference. Moving to variation 6. This was a variation to the proposed Waikato Regional Plan, and it was a significant water allocation plan change. When notified, I'm sporting the surprise of going back. When notified, the provisions explicitly sought to move away from a first in, first served approach to water allocation by introducing common expiry dates on water permits to enable all applications to be dealt with at the same time, and then giving preference to particular types of water use ahead of others. While that approach was not ultimately pursued by the Regional Council on Appeal, it did set the scene for a framework of rules that gives preference to certain types of water use by making some easier to get consent for than others. Because of this approach, all of the major user groups of water were represented at the hearing, and they were all doing their best to get the best spot in the queue under the new regime. The Waikato River Iwi Trusts look to secure a favourable control rule, that is one that must be granted, for iwi development, essentially affording preferential treatment to the 5 river iwi. Their proposed definition of iwi development linked the taking and use of water to development undertaken by the named iwi within their rohi and in respect of Māori land administered under Te Ture Whenua or land owned or leased by an iwi authority on their behalf for their benefit. The council didn't accept that they could do this. They relied on the Hauraki case and argued that a preferential rule was beyond their power. The Iwi River Trust sought to distinguish Hauraki on the basis that there had been some changes to Section 30, but probably more importantly, the vision and strategy enacted by the Settlement Act had come into force since that case. The Environment Court, though, wasn't persuaded that the Settlement Act and vision and strategy extended to the functions and powers of a regional council under the RMA. This, they said, would require clear and unambiguous rules to override the Principal Act, which creates the functions and powers of decision makers. The Environment Court considered itself bound by the Hauraki case and held that while the rules in Variation 6 can provide a favourable status to an activity and apply to anyone who partakes in that activity, they cannot be based on a person's race. The third case, Ngāti Mākeno, a bit more recent. In this case, Ngāti Mākeno appealed the decisions on the proposed Bay of Plenty Regional Policy Statement seeking provision for a cultural allocation. An RPS cannot contain rules per se, but can contain directions that must be given effect to by regional plans which do include rules. Ngāti Mākeno sought a cultural allocation for a percentage of water based on kaitiakitanga and or mana whenua links to a water body. This water would be set aside for iwi and hapu, and they would be able to activate this through a consent process at the point in time they wanted to use it. The court looked at the two cases I've referred to and found that they did not say that plans can't, in appropriate cases, recognise and provide for tangata whenua based upon the proper application of cultural and other principles under the Act. As it turned out, the hearing itself focused largely on whether or not the RPS should require water to be allocated for cultural uses, which is an activity. Importantly, the court thought that cultural use could be both in-stream and out-of-stream uses. That is, water to be left in the water body for the maintenance and restoration of mauri and other in-stream values, and water that is to be extracted from the water body for out-of-stream cultural uses. The court said that we're unable to see any reason why an allocation could not be made for cultural use, provided the relevant water plan contained appropriate mechanisms and criteria. As far as the RPS was concerned, it also couldn't see any reason why that higher order document could not recognise tangata whenua values and the need for a water plan to provide some flexibility for future tangata whenua developments, either by a cultural allocation or including it as part of the in-stream values until it was required in the future. It's quite good so far. It did, however, qualify this by saying that it could not be done arbitrarily or generically, but would need to be specific to the local circumstances, and the court agreed with the premise of the other cases that a rule could not amount to a priority allocation to particular applicants or particular individuals. What exactly cultural uses would involve was left to be worked out through the regional plan review process, because further work and consultation would be required. As a result of the case, the RPS was amended to specifically require for this to be done. And arguably, this decision has gone a step further than the previous cases, although I do not think that it opens the door to the kind of allocation that I'm discussing. So in terms of the Tasman Regional Plan, it's a close example of an iwi allocation. The Council has identified within its plan uses to be reserved or preferentially allocated. The first is for future community needs, and the second is for the irrigation of Māori perpetual lease land. Water is reserved for the irrigation needs of Māori perpetual lease lands until those lands are returned to Māori landowners. In addition to making the reservation of water, the transfer of consents away from these lands is a non-complying activity. This is to ensure that Māori landowners will retain access to water for irrigation in the future when they regain control of their lands. Where allocation has already reached maximum levels, when water does become available, priority is given to the reserved irrigation needs of these leased lands, and other potential users are put on the waiting list. These provisions weren't tested in the courts, but I do think that they would have, I don't think they would have offended or necessarily been inconsistent with the reasoning in those other cases. This is because arguably the reservation is not for a particular class of persons, Rather, it is for a specified use or activity, which is irrigation, and it's for a particular class of land tenure, Māori perpetual lease land. But it certainly pushes the boundaries. Again, this is a way of achieving a type of allocation which protects iwi interests, but is one that is constrained and does not tick all the boxes in terms of offering Māori absolute flexibility in terms of how they choose to benefit from that allocation. I understand that the Bay of Plenty Regional Council is proposing an initial change to its water plan to start giving effect to the NPS freshwater, and it's yet to be seen whether they deal with cultural uses at this stage or leave it to the catchment-specific processes that are intended to follow. The catchment-specific processes would arguably be more in keeping with the court's view that defining a cultural use needs to be specific to local circumstances. So what is possible? In terms of whether an iwi allocation for commercial use of the kind envisaged by the article, whether that's legally possible, I think the short answer is not quite, at least based on the current court authority. This is because an allocation based on the iwi status of the applicant is unlikely to be considered an activity under Section 13. Allocation for certain customary or cultural uses, including out-of-stream uses, is possible, although these would need to be clearly defined. Any attempt to provide for iwi development or similar will face a hurdle when it comes to defining what that development covers. This is where the issue of focusing on the person undertaking the activity rather than the activity itself comes into conflict with the current Act. If a use could only be cultural, this would also limit the ability to lease or transfer that water to others for value, which lessens the economic value that iwi could derive from that allocation. For example, the ability to take water for the purposes associated with marae or papakainga will be of limited use to non-Māori who may otherwise be willing to lease that water from iwi for another purpose, such as irrigation on farms. The setting of in-stream minimum flow requirements that recognise and provide for cultural values are of course provided for. In recent years, a number of different models, indices and approaches have emerged that try to identify the amount or level of water necessary to sustain and enhance mode. These tools will no doubt play an important role in the next round of regional water plans under the NPS freshwater. Tangata whenua can also be involved in governance, decision-making and planning under various mechanisms both in the Resource Management Act and in the Local Government Act. Ultimately though, that doesn't change the legal position. Iwi couldn't allocate to themselves water simply because they are in a decision-making role. Iwi would still be bound by the limits of the current regime and the law. What needs to happen? I've explained that under the current framework, there are ways of allowing for out-of-stream use for cultural purposes and potentially for uses on certain types of land. But that framework does not allow for an allocation to certain people or for use by certain people. In order to derive an economic benefit, that is to allow iwi to develop using water either themselves, with others, or through receiving income from leasing their water, their interest in water, changes would need to be made to the existing framework. To put the issue beyond doubt, there would need to be some amendments to the RMA and possibly the NPS freshwater as the key documents governing freshwater. There are a number of ways the RMA could be amended, but the most obvious way would be to expressly provide for iwi allocation as an activity. This would enable the regional councils to make rules around allocating water to iwi. There may also be a need to amend the transfer provisions to ensure that iwi can maximise any benefits in the short term in the event that they are not yet ready to use the water for their own developments. This also ensures an efficient use of water in the meantime. The NPS for freshwater currently provides high-level direction on tangata whenua interests and values, and this could probably be amended to more explicitly provide for additional values, like the right of iwi to develop, to ensure that these sit alongside all other values that guide the process of setting objectives and limits under the MPS. While the changes to the legal framework to enable an iwi allocation may be relatively straightforward, again the policy and principle shift that would need to sit behind any changes are not quite so simple. So in terms of implementation issues, there's a whole raft of challenging issues that would need to be worked through in terms of implementing this kind of change. So some of what I see as being the key ones would be what amount of water or percentage of water should be allocated to iwi and how would this be determined? How would council address allocation of iwi and hapu with overlapping rohe, which will be a big issue in the Bay of Plenty? And how would council make it fair amongst iwi across their regions? Would the approach need to be consistent in each catchment? And how would you address the fairness of in some catchments being fully allocated and no water being available to allocate, and in other catchments there's plenty of water? In fully or over-allocated catchments, must the regional council allocate to iwi in anticipation of expiring consents? And if so, how do we determine what sector the water should be taken away from? And look, further RMA changes to help facilitate freeing up water during the term of existing consents could help. A change to the Act could allow councils to use their review powers under section 128 to review existing consents to require the use of water to be more efficient, thereby freeing up water. Also, the review power could be extended to allow councils to look into consents where the water is allocated but is not being used, which I believe is relatively common. Also, would an iwi allocation extend to other types of water, so groundwater or geothermal water? Do you notice they're all questions? There's no answers. So is this a radical change? That was the question posed by the writers of the article. Theoretically, the tools to enable an iwi allocation of fresh water are broadly in place, although some changes are likely to be necessary, both to recognise that an iwi allocation is an activity and to provide necessary direction to regional councils through the National Policy Statement for Fresh Water. When looked at practically, providing for an iwi allocation is simply a matter of accommodating an additional category of user for an already competitive resource. Just as regional councils must and do tailor water management to accommodate the specific interests of competing users, the same would need to be done for iwi if the matter was to be left to the regions. Overall, providing for an iwi allocation will no doubt add complexities to an already complex water allocation framework, though this is not fatal to it being achieved. Regional councils could address the matter within their freshwater management functions, but national direction and clear implementation guidance would be critical, in my view, to provide some certainty for all parties that are involved in the process. My concluding comment is the New Zealand Herald, I read this article in May, the New Zealand Herald published an article in May this year by someone called Susan Guthrie, who's an economist at the Morgan Foundation. She criticised the quality of debate about Māori rights to fresh water and suggested that the government, instead of developing policy, has wrapped all of what she called the tricky issues together under the mantle of resource management, turfed them off to local government, and now waits from afar, confident that none of what emerges will stick to it. In light of the work that's been done by both host councils to work with tangata whenua on the issue of freshwater management, the suggestion that central government is pushing down the tricky issues to local government may resonate with many of you. However, without law change of the kind I have discussed, the ability of councils to be able to meet any request for an iwi allocation to support iwi development is somewhat constrained. constrained. Central government guidance in this area as soon as possible really is needed. Kia ora.
Look, I have or I suspect, and I'm a little concerned again, that water applications are becoming a form of water banking. Whether or not there is an intended use. In particular, I think it's happening in this Rohe right now. And if my perception is correct, do you have a view? And do you think this is best practice for the water as a whole? Gil?
No, it's not best practice. I'm surprised to hear that it's happening because under the current regime, an applicant needs to demonstrate a need for the water they're applying for, and the council should critically assess that that application has demonstrated that the water that's been applied for is actually needed to support the activity that's been taken forward. Where I've seen more water allocated for what's needed is perhaps in pre-RMA consents, when it was really easy to get consents. They're usually only on one page. And if they were granted under the Water and Soil Conservation Act, they were grandfathered under the RMA and don't expire now until the 10th of October 2026. That's why I suggest that a helpful change might be to allow regional councils to review those consents, to free up that water and put it back in the allocation pool for others.
Thank you. You talked about transfers and in particular the use of water on Māori land, and many Māori people lease their land, and the user of the land sometimes has a water permit, but that water permit is not in the name of the owner of the land. So when a lease expires, there's an ability for the water permit holder to take the water permit away with them, away from that land. And that could be problematic in an over-allocated area. You talked about cultural uses and the possibility of the transfers staying with, or water rights staying with the land. Do you have any advice for Māori landowners with those circumstances and how they might retain the water used on their land for their use after the expiry of a lease?
Yeah, I understand the issue, and it's clearly the issue that Tasman faced, and the solution they found, which I went through, is to have a rule in a plan that doesn't allow that to happen. Of course, if the lease terms are already set, and those lease terms didn't include a restriction on the leaseholder transferring water rights away, then there's a gap there. So currently, the best approach would be to raise that issue as part of the water plan review and try and mirror some of those Tasman regional plan provisions to protect the value of those leased lands when they're no longer leased. And of course, this is a major difference between land use consents and regional consents. So land use consents run with the land, and regional consents stay with the consent holder.
Kia ora, Lara. You were talking about the MPS in Objective D1. I was just wondering, when it says that the policy is that councils must take reasonable steps, how is a reasonable step defined? Because what I might believe is reasonable may differ to someone over here. Do you have a definition?
The NPS doesn't have a definition. Reasonable steps to me would mean genuinely, meaningfully making efforts to involve tangata whenua in decision making, in the planning process. And with the collaborative processes that I've seen established, and they're relatively new, they sort of weren't, I don't recall them being around 10 or so years ago. Mediations were more about everyone turning up with their own interests and then just staunchly defending their position, whereas in this era of collaborative planning, there seems to be more willingness to understand and work with the other stakeholders and interested groups to try and find an outcome that benefits everyone as best it can. So in terms of taking reasonable steps, I think now that requires collaborative planning processes. It'll be interesting if the Resource Management Amendment Bill goes through, although I hear it might not, because within those amendments, the Regional Council has a choice to go off in two directions. One is the current direction where ultimately they retain the decision-making power, but under the Resource Management Amendment Bill, there's another avenue for plans to essentially transfer that power to a collaborative group, and the decision maker must give effect to whatever recommendations come out of that group on which there was consensus. So if that collaborative group came up with a list of things that they reached a consensus on, the decision maker must give effect to those things. So it'll be interesting to see whether that, firstly, whether the bill goes through, and secondly, whether council, because it's not mandatory, choose to exercise that discretion to go down that path. Certainly, if they do, everyone will want to be on the collaborative group. So we might need a room like this. If I've understood your question correctly, are you asking whether or not pursuing sort of specific cultural uses in an allocation framework somehow...
We talked about activities that talked about prioritising the activities, and you also talked about we may have a chance with cultural activities.
Yes.
In your personal opinion, is there a possibility of how much of a opportunity for us to combine those and tweak it to get to the top of the list while we're waiting for the powers that be to change everything to make it easy for us?
Yeah, okay. So in terms of cultural uses, I think there's a great opportunity to seek priority and preference in the freshwater management framework. It's a little bit of semantics, because if you can figure out a way to define a cultural use that enables a commercial use, no matter what the activity is, then I'm sure you'll find a lawyer that will argue that that's an activity. think we're trying to twist the system to make something happen, to achieve something that probably hasn't been the intent. And that's why I say, you know, the central government work streams need to get on with it, rather than push these issues down to the regions to try and sort out within a framework that this doesn't squarely sit into.